My name is Dylan Delanka Senavarutna. I'm a resident of Toronto, Ontario, Canada. So this video is about my interaction with York Regional Police, which resulted in criminal charges. The criminal matter is now concluded, and I am appealing the matter due to mistrial. Justice of the peace was found to be in violation or conducting a misconduct, and was removed as a justice of the peace, and is now a crown attorney in the city of Toronto, which coincidentally she just happens to be a crown attorney in a matter that is unrelated to this one. Okay, so to provide a background, I was a YouTube blogger with a YouTube channel speaking on e-commerce entrepreneurship, a clothing line, Amazon partnership, etc. At that point in time, I was employed with two e-commerce companies, one a Amazon partner, and the second one was a clothing line that I had started. I was an Army applicant who had been invited to do a Army testing for fitness and continue the application process. I was a university student at the University of Waterloo for logistics and supply chain management, and I was also law enforcement. I was a licensed Ontario for the province of Ontario, a Ontario private investigator and security guard, and I had no criminal record at the age of 27 in the year 2020. So this event occurrence dates to July 5th, 2020. So what happens is that York Regional Police initiated traffic stop at 1 a.m. The reason for this traffic stop is that they observe a vehicle traveling from their account is at 20 kilometers, which is slow in a 60-kilometer zone. So they approach the vehicle and then they stop the vehicle, at which point they ask the occupant to exit the vehicle due to the smell of cannabis. So now we have obtained disclosure and dash camera CCTV from the vehicle. So as soon as the vehicle begins to follow a vehicle for a traffic stop, the camera starts recording, at which point the vehicle of the police vehicle, the speed is displayed on the video. So they are traveling at approximately 63 kilometers. So if you are bumper to bumper behind a vehicle going at 63 kilometers, it would be highly unlikely that the vehicle in front of you would be traveling at a lower speed of going at 20 kilometers, because you would obviously collide and overtake them going at 60, at a 40 kilometer per hour difference. So the next thing is, and we will be uploading a video, the dash camera video, as well as footage from that and the documents. So the next thing is that they say that there was the omittance of cannabis from the vehicle, but there was not enough cannabis to be tested, which means that you would need at least a 0.5 or a gram of cannabis or dried cannabis, flower, marijuana, to be tested to be marijuana. So that means that would be less than a gram, possibly residue. But the issue with that is that due to my e-commerce and things of that nature, I do have apothecary, which is a combination of herbs, flowers, and dried flowers and things of that nature. That is something that I want to venture into. That is the reason why the container was there, that they said was marijuana but never tested to be marijuana, and that is the reason why they asked me to exit the vehicle. And they stated that the marijuana was discarded, never submitted to the evidence room, and it was discarded because it was too little to be tested, which is strange, because I would think that you would submit any evidence into the evidence room at the minimal stage, whether it could be or could not be tested, just as photo evidence or whatever evidence it may be. So now the police come and they speak to me. There's a police officer on the driver's side and the passenger side, and they speak to me for about 10 to 15 minutes, looking inside the vehicle with flashlights, and they do not seem threatened or in concern or danger for their safety. So at which point they asked me to exit the vehicle. It's about 15 minutes after they had started speaking to me, or 10 minutes or so. So at which point they began to search me. Then they take me into custody, and then on the dash camera, the police officer blocks the view of the camera on the passenger side, leans into the vehicle. I believe to do what he did was place a firearm in the passenger side because he blocks the view of the camera and leans into the vehicle and then says, "Oh, look, there's a firearm." So how did you not see a firearm for 10 to 15 minutes in plain sight on the floor of the vehicle? And you were calmly speaking to the occupant of the vehicle and then ask them to exit. And then once they exit, you block the camera and then say, "Oh, look, a firearm," which is highly suspicious. At which point I'm taken into custody. I'm transferred to the police unit, held for bail, kept in custody for a period of 3 days, and then given bail. So during this traffic stop, there is an amount of currency, Canadian currency. It states as unknown amount. So the contradiction and the issue that would lead to believe that this is fabricated and false statements by the police is that I get out of the vehicle with a liquid beverage container, or orange juice container, a Minute Maid container, about 375 milliliters, and the beverage is already consumed. About 3/4 of the beverage is already consumed, and there is only about a quarter left. So I placed this on the hood of the police vehicle once I exit the vehicle, and this liquid container stays on for the duration of about 30 minutes or 40 minutes. There's vehicles passing by at a fast speed at about 80 kilometers per hour, which rocks the vehicle. Even the vehicle is, you can hear the vehicle being moved by the force of the vehicles passing by, but the bottle sits there on the hood of the car. There's no wind, absolutely nothing that makes the bottle fall over. So now the police get in the vehicle, and on the dash camera, CCTV, or the in-car audio, they state, "We will count this money, the currency, off a view of the camera and handle it separately because it's too windy to count it on camera." So if it was too windy for the bills and the bills would float away, how does a bottle that has less than 20 milliliters of, close to 30 to 40 milliliters of liquid in a plastic container, manage to stay on the hood of the vehicle for 40 minutes with absolutely no wind? If you look in the trees in the surrounding area, they're not even rustling from the wind. It's a hot summer day, so there's absolutely no breeze because it's the middle of July, or it's the beginning of July. It's July 5th. Hot, humid, summer night, no wind, absolutely none. So I think you could see the profile of these two officers, where they say that they have currency that they need to count but won't be counting it on camera due to it being too windy. I believe they were putting the money aside for them to keep personally, because how it works in Canada is that if a person is arrested with the amount of money that is to be submitted to their canteen or onto their inmates account, inmate trust account, so the money is deposited as money that the person was arrested with. So what happened here is that they kept the money. They said that it was too windy to count the amount on the camera. It was absolutely no wind. That the bottle is proof of that. The liquid bottle is proof of that. And they ultimately keep that in a separate bag, or I'm not sure if they bagged it. They don't bag the money, and then once they get to the police station, they report it as an undisclosed amount. One, and two, they did confirm that it was an amount. However, they didn't put the amount in writing, and I believe that was in an effort to take the money that was there, because there is no other reason. The procedure is that they have to submit that money, put the amount, and then submit it to the trust account of the inmate. So during the stop, the other thing is they do not read me my rights. They put me in handcuffs, then they put me in the vehicle, then they come back afterwards after doing something else, then they come and read me my rights. The other issue is that they initiate a seal and seize of the vehicle. seizure of the vehicle. So pretty much the two officers are not may not know exactly, have too much knowledge of how to initiate this, so they call a supervisor. The supervisor tells them to immediately stop touching the vehicle and to stay away from the vehicle, to seal it, seize the vehicle, have it towed to the police lot where they will further initiate a warrant and search the vehicle, obtain a warrant to search, and then so a judge has to give a warrant, sign a warrant to search the vehicle, at which point they will search the vehicle and then confirm if there was a firearm or not. But at this point, obviously the police officer had already reached into the vehicle and appears to place a weapon in the vehicle. They don't stay out of the vehicle and instead ask me to step out of the vehicle and then obtain a warrant or seize the vehicle. They first attempt to search the vehicle, at which point the officer blocks the view of the camera and then leans in and then says, "Oh, there's a firearm," about 20 minutes into the interaction or into the stop. And then they ultimately called the supervisor, at which point that's when they came and towed the vehicle, seized the vehicle, sealed it. But you can also see the police officer wiping down the fingerprints he puts on his gloves. The supervisor, once he arrives, he puts on black gloves, starts wiping down the handles of the doors, and wiping down the vehicle on camera view. Clearly on the camera, he puts on his gloves deliberately. He speaks to the officer, who seems a bit concerned that he touched the vehicle and executed an illegal search. So at this point, the supervisor, the senior, who arrives on scene following the arrest, and I'm already handcuffed and in the vehicle, detained. He then goes and puts on black gloves, starts wiping down the handles with the sleeve of his police uniform. So that takes place. Then they transport me to a police facility, division precinct, where they hold me overnight and transfer me to a correctional center where I'm held for remote video bail at the courthouse. And then I'm given bail on July the 8th. And the issue with that is that I had a surety there as well as legal counsel, but due to the previous weekend being a long weekend, the court said that they were backed up, and they didn't have time to hear my bail application, so they pretty much they adjourned the matter and then brought me back. That matter was heard on a Friday, which was the 5th, then the 6th, the 7th, the 8th. I was released on the Monday following, and that's when I was adjourned and given a court date for this matter. So now I'm brought back to court sometime in September. So from July 2019, I'm released on July 8, 2019. I'm brought back in September for my first court appearance before the Newmarket, Ontario Court of Justice, at which point I was in front of various justices of the peace, and ultimately have a discussion with a lawyer in the city of Toronto who also practices in Newmarket by the name of Singh. So I contact Singh as legal counsel. I meet with him in his Toronto location, Toronto office. We have a lengthy discussion about my legal criminal proceeding, and I attempt to retain him as a lawyer. I believe we may have signed paperwork. He did appear as legal counsel for me in the court and state that he is counsel on record and that I'm giving him a certificate for retaining him. So then we are adjourned, and at the next hearing there is an issue with the audio. So they say that they do not have the audio for the transcripts at this courthouse for the two appearances. Then they state that the former legal counsel, the person that I tried to retain, Singh, is now a Crown attorney and can no longer accept my case. But he refuses to handle the matter as a Crown. They ask him to handle the matter as a Crown. He refuses because he says, "I've already discussed defense with this man and I've come on record as counsel, so that would be inappropriate and a misconduct for him to handle the matter. So that's on account of Singh, the Crown Attorney, who states that he will not be be a prosecutor in this matter because he was former legal counsel, and in error of the court, they were trying to proceed with him as a Crown Attorney. That's one concern. Another concern is that there was the issue of 2 appearances not being recorded. They're saying that they don't have a audio at the courthouse, even though I have photos of the court docket that date of my attendance. I have multiple witnesses, including the Crown himself or the former legal counsel, and the adjournment slips for that date. So I do have photographic evidence that I was in the court that day. I have witnesses. I have other transcripts that state that it's the next appearance date. I have the reminder slips as well, the adjournment slips. So at this point, the 2 dates that they don't have audio recording for, the justice of the peace in those matters hurl racial slurs at me. They say racial slurs like the N-word. They say other things like you're not a lawyer, whatever comes to their mind at that time. That's why they did not have the audio recording, because they said racial slurs that date. So ultimately, I filed a complaint with Ontario Judicial Council, which is the governing body in the province of Ontario that investigates misconduct by justice of the peaces or judges in Ontario. So I complained against her, and now she is a Crown Attorney. She is no longer a justice of the peace at a different courthouse location at 1000 Finch in the city of Toronto. I have a transcript of this justice of the peace presiding over my matter, and then I have a document from the Ontario Judicial Council that states that they are investigating and inquiring into her conduct in regards to my matter in Newmarket. And ultimately, she is now the Crown Attorney, which I have a document of at a different courthouse, where I also have a different matter, unrelated matter, where she is now the Crown Attorney, and I'm pursuing civil action for malicious prosecution and abuse of process by the Crown, and this is the same Crown that I complained against when she was a former Justice of the Peace. So now in the case, the police officers, they do not attend court because it was an illegal search. They say that they reached in the vehicle and seen a black article of clothing, a hoodie to be specific, a hooded sweatshirt, at which they say they pulled the sweatshirt back to reveal a firearm. The issue with that is that they were to seize the vehicle, seal the vehicle, and not execute a search until they obtained the permission and the warrant from a judge, which would give them permission to search the vehicle. So when he leans into the vehicle, 1, on the vehicle camera and blocks the camera view, and then places something in the vehicle. 2, he's been speaking for 10 to 15 minutes and never seen the weapon, which he claims was in plain sight. Then 3rd, he says that he uncovered the weapon after folding back a piece of clothing. So you are stating that you reached into the vehicle, you admit that you reached into the vehicle and moved around a piece of clothing, which is off view of the camera because he blocks it. So now you admit that you have reached into the vehicle and touched the property of the vehicle without a warrant, and then you say that you see a firearm, which you didn't see for the past 10 minutes while you're peering into the passenger seat the entire time. So there was obviously no firearm there. There was simply a piece of clothing there, if there was that. And then they pretty much produced a weapon, which he probably pulled out of his waistband or something and placed it in the passenger side. But ultimately, I am in custody for a different matter in the year 2020. So I plead guilty to this firearm charge because I've been on house arrest for 10 months and in custody for close to 7 months in a prison correctional complex during COVID, the height of the COVID pandemic, and we're not getting out of our cells at all for more than even a period of 20 minutes every 3 days or so. We're not getting showers for over extended hours of 72 hours. The staff are not coming to work because there's confirmed cases of staff being COVID positive. inmates being COVID positive, so the entire complex is on lockdown and restricted. We're not receiving legal documents. We're not receiving phone calls to speak to counsel. We're not even able to sign documents at this point in time. And they tell me, if you want to go to trial, you'll have to wait a year, or you could plead and take a time served. I'm being threatened by correctional officers who are saying that if I do not plead guilty, they will harm me, or give me, put me in cells with COVID positive people and things of that nature. So for concerns for my safety, I plead guilty because I have a time served position, and they released me from custody with an extra 30-day sentence, a total of 475 days or 15 months, for a first-time nonviolent offender at the age of 28. So now I have a criminal record. My first conviction as an adult is for a firearm, an unloaded firearm, nonviolent crime. That is my first conviction as an adult, and I'm given a sentence of 15 months, partially in in custody, a custodial sentence, which means to be served at a correctional center, a provincial correctional center, which is under 2-year sentence. But the issue with that is that it was the height of the COVID pandemic, and even staff, where it was a short-staffed situation. So we were not getting access to anything. There were multiple human rights violations and things of that nature. No showers for 72 hours. We couldn't access the phones. We couldn't access our lawyers. Things of that nature. Court was being canceled. Court was being canceled. So people weren't attending court because the COs would not take them to court due to COVID restrictions, things of that nature. And we're on 23 hours lockdown. Sometimes 24-hour lockdowns for extended periods of time, like 3 days at a time, where we're not allowed out of ourselves at any time. So ultimately, I plead guilty, and so I filed a complaint against the Justice of the Peace. There's multiple misconducts, a lot of fabricated evidence, contradicting evidence. I never got a chance to have a fair trial. I feel that I will be appealing this because I feel that there were clear accounts of misconduct by the Justice of the Peace, the Crown's involvement, where he was a former counsel, audio recording that is missing for transcripts, two dates where the audio recordings are missing for transcripts, racist slurs being said by the Justice of the Peace presiding over the matter, which he was found guilty of and removed as a Justice of the Peace. I can't understand how they even accepted a guilty plea or continued this. They should have withdrawn the case because the police didn't attend court either. They were not coming to court. And the trial would definitely not have been a guilty, would not have been found. I would not have been found guilty because, firstly, the reason for the stop was the cannabis. There was no cannabis submitted to the evidence room. That alone should have stopped this case. And being in a compromisable position where I had health and safety concerns is the only reason I pled to this matter without a fair opportunity to go to trial, when I was also being threatened by employees at the Ministry of the Solicitor General. And I have a reported incident where I was attacked by guards on 2 occasions. On one, I was pepper sprayed and taken to the ground and not being able to wash my face and placed in isolation. And the second one, they attempted to keep me from contacting my lawyer. And the day before I was released, I sustained severe injuries, swollen knee, abrasion, lacerations, long-term injuries. I still have a year later. I have pain in my neck, which I'm going to the doctor for. I have pain in my wrist, my knee, my hip. I've gotten x-rays, things of that nature. I have PTSD, nightmares. I have trouble sleeping. Sometimes I get panic attacks, anxiety attacks caused by this situation. So during this incarceration, I'm also given probation for a misdemeanor of uttering threats and mischief. These are all first-time offenses around the same time frame in the same year, all in 2020 or 2019, 2020, because I'm in custody all of 2020 from May 25th, 2020 until January 29th, 2021. So I'm given probation order for 18 months by a judge, justice of the peace, who presides over 4 of my matters. So ultimately, one being a federal matter which he has no jurisdiction over, which is the firearm that I pled to. So there was a misconduct of this justice of the peace handling 4 matters for the same accused, or for the same defendant, which is me. So that judge handles, justice of the peace handles 4 of my matters, and assigns me probation for 18 months, and denies my probation variation to have a so I have a condition 11 on my probation order, which states to participate in counseling as assigned by a probation officer. So now I have 2 probation officers removed by the Ministry of the Solicitor General, who deem them to have committed misconducts or inappropriate behavior which caused them to be removed. I also have a lawsuit against civil litigation against one of the probation officers who lied during the probation hearing, who also canceled my appointment with the psychiatrist at the probation office, who also lied and told me that he had scheduled an appointment with the counselor at the probation office, and 3 months later he says that he will be booking it again, which I was under the understanding that he had already scheduled this. And then the probation officer who is assigned to me now, so the 3rd probation officer, confirms that he did not book anything. He goes back and asks him. I do have audio recording of all these situations, as well as documents from the probation office that state that the probation officer had, 1, canceled a psychiatrist appointment, then 2, he had stated that he would schedule an appointment with the counselor, and then ultimately tells the new probation officer 6 months later that he had never scheduled any type of appointment with the counselor. But he told the court that the defendant was, or the probationer, or the person on probation was pretty much denying any counseling or a psychiatrist, which is ironic because I have a report from the psychiatrist, as well as the counselor, and witnesses from the other probation officers, and audio recording and email communication that state that the probation officer was lying to the probation office as well as the court, and saying that I was denying everything when he's the one that failed to schedule an appointment, and he also canceled an appointment that was already scheduled to have a violation of one of the conditions, and I do have civil litigation against him for this. So both those probation officers were removed, and now I have a new probation officer who ironically was able to schedule the same counselor within 3 meetings. That means a month and a half, within a period of close to 40 business days, or 3 meetings. He was a month and a half. He was able to schedule the counselor that the previous probation officer failed to do in 6 months, and reported to the court that I had denied all assistance, which was a complete lie, fabricated, and fraudulent claim. So ultimately, the probation psychiatrist brings forth, as any mental health practitioner brings forth, a confidentiality, doctor-patient confidentiality agreement, which he is in infringement of because he disclosed this information to the court for the ongoing matter in Toronto, and states that he's willing to participate, at which point I make the court aware, the justice of the peace, the judge, aware that he is my probation psychiatrist, and that I did not give him permission to disclose any information. I did not discuss harming anybody, self-harm or harm to children. So at which point he would be an infringement. So I request these documents from him, at which point he tells the manager that this document was never created. So according to Mental Health Acts, laws, and mental health practitioners and the College of Physicians Surgeons of Ontario Mental Health Association, the Medical Association of Canada, Canadian Medical Association, there is no way that you would be able to write a report or do any type of health practitioner work if you do not have a client, patient, doctor agreement as far as the mental health field is concerned. So he is in violation of this. I filed a lawsuit against him for fraud, for defamation, for medical negligence, medical malpractice. So he is removed as a probation psychiatrist. the court, the justice of the peace, ultimately asks him to refrain from communicating with the Crown because that is an abusive process by the Crown, to try and discuss the defense counsel with a third party who has information of the defense counsel strategy. Plus, he is in infringement of the doctor-patient agreement, confidentiality agreement. So at this point, the Toronto matter is the same justice of the peace from the Newmarket matter, the firearm matter that I complained against, and she was removed as a justice of the peace from Newmarket and given a position of Crown Attorney in the Toronto courthouse. So now she tries to use the probation. She is acting in reprisal and revenge for me complaining against her, having her removed as a justice of the peace, and she's a Crown Attorney on my matter, on my Toronto case. So she tries to seek the assistance of the probation psychiatrist, and she ultimately tries to seek their assistance, which is rejected by the court. So I bring to the attention of the court that this Crown Attorney was a justice of the peace on my former matter, which I've been convicted of and plan on appealing, because the misconduct was that this lady was removed for her misconducts during my matter, proceeding over my matter. So now I make the justice of the peace aware. So they placed me on house arrest for a period of close to 9 months post-release from the sentence for the firearm. So from January 29th until current date, October 10th, 2021, I'm still on house arrest, but they withdraw certain charges, indictable offenses from my matter, and they continue in violation of Section 11B of the Charter of Rights and Freedoms, which is the right to a trial in a timely manner. So they schedule my offenses in Toronto for 18 months from the date of the charges being filed, a total of 24 months from the date of the occurrence of these events for summary convictions of misdemeanors. And they schedule a trial for March 21st, 22nd of 2022, which is a total of 24 months from the date of occurrence and 18 months from the date the charges are filed. So I bring this to the attention of the court. We filed multiple motions to dismiss, some of which have been accepted, and some charges were dropped while some others remain, the less serious charges. And we're at a standstill right now, and they're using this to keep the house arrest because they fear that there is a threat of violence when the police records imply that I did not have a criminal record until the age of 27. I pled guilty to a unloaded firearm. I have no violent acts. I'm a non-violent first-time offender, and that charge I will be appealing for the misconduct and mistrial. And I believe that that was in an effort to make me appear to be a violent offender. I have no violent offenses, so these are fabricated and fraudulent claims. And I believe that this is due to racism. I believe the only violent and scary thing about me is my skin tone, my skin color, being that I'm of a darker skin tone, and that I'm an immigrant to this country, that they are using this opportunity to exercise racism, blatant racism, breaking multiple laws in the abusive process by the Crown Attorney, malicious prosecution. I've sent multiple complaints to the Ontario Judicial Council, and they're investigating the conduct of the judges as well, who have exchanged private numbers during a hearing. So the rest of the concerns is the police conduct. So placed on house arrest, I'm released from the correctional facility on house arrest. So I reside at a townhome, a residential area, a residential neighborhood. And this property is owned by my family, who is my surety, and it is a quiet residential neighborhood. There are no apartments around, things of that nature. There's just semi-detached, detached, and townhomes in this area. Relatively new, all built around like 2010 or so, and upwards of that. So So it's a very quiet and residential neighborhood in the city of Brampton. So pretty much the police officers they so some pretty much somebody unidentified police officer comes to my door. They don't have regular police uniform on. They don't have the Region of Peel or the Region of York or Toronto police uniforms. They come to the door. They knock on the door way after dark at 11. So I do have recordings of these videos. So I have my CCTV for this residential property. Those cameras as well as my cell phone video of these officers attending. So they pretty much attend the property at about 11, which is an inappropriate time. Unidentified, no badges, no names, just a vest, a tan colored vest on, or plain clothes. And then they state, oh, we're here to do a house arrest check. I'm in the Region of Peel, which is about 40 minutes from the nearest border, so the Toronto border Steeles. I live a few intersections north of that at Highway 50 and Coachella. The nearest Toronto intersection would be Highway 50 at Steeles, which is about a 20-minute drive. But for Toronto police, that would be about a 40-minute drive into another city other than Toronto for them to check on a house arrest for a non-violent offense, a property damage property mischief charge with misdemeanors, summary offenses, and not indictable offenses. So it appears that there's something going on here where they're attending to check if I'm actually abiding with the house arrest. So I make a complaint to the Toronto police, who ultimately state that these are not Toronto police officers, where I'm on house arrest with the Toronto police, not any other region. I have no other ongoing matters or open cases. So I have a Toronto matter with the Toronto police, and then the Toronto police, once I contact them, state that this is not Toronto police, that they are not doing house arrest checks for these offenses, because they have more serious offenses, obviously, like murder, rape, robbery, things of that nature, arson, right? So pretty much they forward this complaint to Peel Regional Police, where I reside, Peel Region. So they notify the police that somebody is coming to my door and without uniform or ID, and stating that they're police, which is a threat to my safety, because what if they're doing a home invasion and disguised as police without a police uniform or badges or identification, or verbally identifying themselves as such in a region where I'm not even on house arrest through their police service. So ultimately, I contact the OIPRD, which is the governing body, Ontario Independent Police Review Director Board, to have them to file a complaint. They reach out to me from Peel Region, because Toronto Police forwards it to Peel Region and states that there's an issue here. So they contact me, they come speak to me. They show me a profile of the officers that attended and say, are these the officers that attended? I say, yes, that is. So they say, okay, there is obviously an issue there. So I withdraw the complaint because they made the effort to come and contact me. I explained to them what the issue was. The issue was that, one, I'm in Peel Region of house arrest in Toronto for summary offenses. If Toronto police is not making an effort to come here to check on me, why is the rope squad or the compliance unit, why are they coming to my house for summary offenses, a misdemeanor of property damage under 5,000, a very minuscule, small, very, very small charge in the scope of the Criminal Code of Canada. So they come to my door, no idea. I informed them that they come at 11, past 11 p.m. In my residence, there are seniors over the age of 65. So there's health concerns, and we would appreciate if they do attend, that they attend in the daytime, possibly before 2 p.m. And the other thing is that I have multiple conditions on my bail release that allow me to, without a surety, to exit my house or my residence and be out in public and attend medical appointments, counselor appointments, lawyer appointments, court appointments, and other appointments as necessary without a surety. While on house arrest, I'm allowed to leave my residence, operate a motor vehicle, or any mode of transportation I wish to use, I could use. I have no restrictions. I'm allowed to go to various appointments without a shirt and by myself. If I choose to drive myself there, if I choose to take a taxi, a bus, whatever the situation is, medical emergencies, and so on and so forth. So there's absolutely no reason why they should be harassing me and coming to my door, especially if Toronto police are not coming themselves. Peel Region Police do not have the jurisdiction to come speak to me about any matters or check on my house arrest, because I'm not on house arrest with their police service or in their region. So following that, and I do not have house arrest due to probation, so I have to comply with my probation orders and comply with house arrest from Toronto, the Toronto court and the Toronto police, which I reside outside of their municipality, because I live in Brampton and Peel Region. So following that, I withdraw the charges against them. I withdraw the charges against the police, at which point they stop attending my residence. I have no further interaction with them. The OIPRD complaint is resolved. There is no further hearing. So that takes care of the harassment, and they stop harassing me, which I should have filed a civil litigation or lawsuit against them for harassment and racism, for mischief to property, because they inform me that they sometimes break the windows, break glass of vehicles, and the door if nobody's home, if nobody answers, which is vandalism and property damage, which is very inappropriate and against the code of conduct and professionalism set forth for police, and they have no business attending a property. And they also showed up to the property without being on, without having their time accounted for. So they would show a different picture of a different police officer and send another police officer who would be covering for them. So if a situation were to happen where I was taken into custody, or an altercation happened, or some type of injury occurred, and the SIU, the Special Investigations Unit, had to investigate, it would show a different officer than the one that was on the police record. So once they go in their record and look and say, oh, this was a person on shift, that would not be the person on shift, because my video cameras, my cell phone footage, as well as my CCTV for the residents and my neighbors, video cameras would show that they arrived in an unmarked car, not a police vehicle, and they came out of uniform, no ID, no badges, did not identify themselves, and then ultimately were not even the police officers that were assigned to be, that they had said would be attending the property or the residents, which is a big issue, because if something were to happen, so how would you explain that you're not even the person that's supposed to be here, but you're here? So I believe that goes against the code of conduct and ethics and professionalism. I believe that was just an act of racism. All the white officers attended. All the officers that attended were all Caucasian, were white. In the photos, they showed a Afro-Canadian officer, or a dark-skinned male as attending, but it was a Caucasian female. I'm not sure what the issue there was, if the person didn't make it to their shift, or if that was a person that was supposed to be attending and he called off or something, but it was not the person who attended. Another officer attended of an Asian descent, who stated that he was there for mental health, for Form 2 through the court, but really it was for a house arrest check, a compliance check. That officer, I did videotape him, also asked him for identification badge number. He ended up taking me to the hospital without being arrested and detained, no cuffs. He just simply drove me there. I voluntarily attended, because I had to comply and complete that for probation anyway. So it did result in the psychiatrist discharged me from the hospital, saying that I had no mental health illness. So these police officers did continue to harass me multiple times. I did file complaints. I complained to the OIPRD as well as the Peel Regional Police, Toronto Police, at which point interactions with them ceased and they no longer attended my property. I believe that, so if my complaints was the reason that made them stop coming to the door, then that means they shouldn't have been coming to the door in the first place, and that they were obviously trying to either assault me, harm me, or do something else which could have caused me harm. And I believe that that's very inappropriate. That could have damaged my property, or damaged or injured the people, the residents of this property. This is a private property. This is privately owned residence, and they should not be attended as property without a warrant or without any reasonable suspicion or anything of that nature. We are all employed. The residents of this house all have recorded employment. No disturbances, no loud noises. This is a household that usually sleeps at around 10 p.m. It is very inappropriate. This is a prime example of police harassment, menacing and threatening police officers who attend properties, destroy properties, harass the occupants of the properties, and things of that nature, which really needs to be addressed and heard in the court of law, and they should be disciplined for this. There should be hearings for their behavior and for their illegal activities, their violations of the Criminal Code of Canada as employees of the government of Ontario or employees as police officers. This situation has been traumatizing for me, to say the least. I have PTSD, anxiety, depression stemming from these incidents, from these police interactions, from the unfair justice system in Ontario, the many misconducts committed by them that have gone ignored. I've been assisted by the OIPRD, the Ontario Judicial Council, the Ontario Independent Police Review Director for the police, and the Ontario Judicial Council for the justice of the peace in the courts. This has been a horrifying experience to see that those who serve and protect us don't serve and protect us, that they harass, threaten, and behave in a menacing manner, sometimes assaulting seniors, destroying property, wrongfully detaining people without a warrant, without a probable cause, without a just reason, simply just to have something to do. This has broken my faith and my trust in the justice system as well as law enforcement. I was former law enforcement. I was a security guard licensed by the government of Ontario as an Ontario private investigator and a security guard. So this has definitely broken my trust in them and my faith in the policing system as well as the judicial system. And I hope that the involved parties are brought to justice, that they are held accountable for their actions, because somebody could have been harmed. And I could have served a jail sentence wrongfully, or I could have been further injured by the officers, as I already was. And I do have injuries that are lifelong injuries that can't be reversed, or would require surgery to be reversed. And I believe that this is due to racism. As I mentioned, I was a nonviolent first-time offender. The convictions are going to be appealed for mistrial. I was a YouTube vlogger. I was employed with 2 e-commerce companies, a Army applicant who had been invited for testing, a university student at the University of Waterloo for logistics and supply chain management. In relation to my career with the Army, I want to work in that field or that sector. I was law enforcement as an licensed Ontario private investigator and security guard with no criminal record. And then within the span of a year, I was given a unloaded firearm conviction, which rightfully should have been withdrawn due to misconduct by the police, and a misconduct by the Justice of the Peace and the Crown Attorney, as well as fabricated evidence, even the videos, everything there was a lot of evidence of fabrication, fraudulent evidence set up by the police, where they placed the weapon in the vehicle, where they admitted to tampering with the evidence before the warrant was given, signed by a judge, and things of that nature. I hope the result will be that my criminal record will be cleared, as it was just last year. I hope that this charge will be appealed and overturned and withdrawn. I hope that all the participants are given employee disciplinary action, termination, or they're disciplined for their acts against the Constitution, against the Charter of Rights and Freedoms, the Criminal Code of Canada, the Justices Act, the Police Act, and the Crown Attorneys Act. And I hope that justice will be served, and that the charter will be upheld. All right, so I want to mention some facts about this arrest. So pretty much, at the time of this arrest, or around the years, so 25, at the age of 25, 26. So I was arrested at the age of 26. I had a life insurance coverage. Well, I had it offered through my place of employment, but I did privately get life insurance due to me having my two e-commerce companies. So I had a $250,000 coverage at the age of 25 for life insurance, with $100,000 critical illness coverage plan. So $350,000 in total in coverage. And had my business tax number, so I was registered with the Canada Revenue Agency, the CRA. My taxes are up to date. I have a record of employment. I do not have a criminal record. During that time, I was arrested up until the age of 27, as I mentioned. But my suspicion for the reason of stop was that they seen it was two white officers, two Caucasian officers. It was a secluded road. There was no traffic. It was 1 a.m. And it was in a 2018 vehicle, 2018 sedan. The year was 2019, only a few months into the year. So January, February, March, April, May, June, July, about 7 months into the year. So that was a fairly new, just the last year model vehicle. So I was in a 2018 vehicle. And I had registered businesses, life insurance and coverage were $200,000 or $350,000. My businesses are registered, so pretty much I had a independent business number, sole proprietor, things of that nature. So I believe that I was targeted by these officers for driving a new vehicle, a black male occupying a brand new vehicle, and appeared to be fairly young. So I believe that was the reason for the stop. I did feel threatened for my safety, as it was dark, it was secluded, there was no traffic. So that's the reason why I asked to be detained immediately. Once they asked me to step out of the vehicle, I was in fear for my life. I was afraid that I'd be assaulted or shot by these police officers. So I immediately asked them to take me in the back of the vehicle, where I knew the audio recording, the video recording would be on in the vehicle if I were to be assaulted. The officers didn't clearly had no comprehension of what they were searching for or what they were doing. They simply stated that I was going too slow, which is a reason for the stop. And I can't imagine me going at 20 kilometers if your dash camera itself states 60 kilometers, 63 kilometers. There's no way possible scientifically for a vehicle in front of you to be traveling at a lesser speed. So that would be a complete lie, a reason for the stop. I believe they seen a black male occupying a 2018 vehicle in the early months of 2019, or about halfway into the year of 2019, and appeared to be in their 20s or a teenager. They probably believed that the vehicle was stolen, or that I did not own the vehicle, things of that nature, as well as they had a fixation on my currency. They took my currency out of my possession, stated that it was currency, but didn't want to count it on the camera of the vehicle, or as they're supposed to do by policy, to count the money in view of the camera. They stated that it was too windy, as I mentioned. There was a beverage bottle which didn't fall over the entire duration of the 40 minutes, with vehicles passing by, such as trucks and stuff, where the wind was traveling at a high speed. The beverage container managed to stay on the hood of the vehicle, the police vehicle, so I cannot imagine bills flying away while you count them, or currency notes flying away on a non-windy day, night, like 1 a.m. Other than that, I believe that they also want to keep that money, because that money, once accounted for and counted, is supposed to be submitted to the property of the detainee, which they did not do that. So I imagine that they kept it for personal spending, for personal use, and took that money, which shows corruption, bribery, misconduct, unprofessionalism, and violation of the criminal code, which is also theft. So I believe that is a reason why. I was also in fear for my life. I did comply with the orders given by the officer and immediately asked to be placed inside the vehicle for my own safety, where I could be recorded and safely kept until they completed their search or completed whatever they need to do. And I was I was taken to the police station without injury, and I was given bail without injury. But I did face racism. I believe that the two white officers felt threatened by me and asked me to exit the vehicle. I had no violent previous record. They didn't even run my ID or go back and see if I was like a offender. They simply just asked me to step out of the vehicle immediately. I believe that was due to my skin tone, my race. They immediately asked me to exit the vehicle. I believe they believed that the vehicle was stolen, and that's why they asked me to exit the vehicle. And then they proceeded with the firearm charge, which, as I explained, they do out of view of the camera and block the camera and then say, "Oh, look, a firearm," after 20 minutes of speaking to me and looking straight at the exact spot where they said the firearm was. So I'm pretty sure it wouldn't take you 20 minutes to recognize a firearm, such a threat to your life. In conclusion, I just want to say that racism is a serious concern, especially within police forces, because they're able to ask you to exit your residence, exit your vehicle, submit you to a search, and sometimes, as the Rodney King, Eric Gardner, and Devontae Miller was assaulted by police officers, as well as the recent Toronto plainclothes officer who assaulted a black man on a TTC bus, whose charges were withdrawn. Chase Richards, who was assaulted by a plainclothes officer on the Toronto TTC bus in the city of Toronto by a plainclothes Toronto police officer who attacked him and used excessive force to arrest him and charge him, which ultimately resulted in the charge being withdrawn against Richard, the man that was attacked, and charges being placed against the plainclothes officer who clearly used excessive force. So I was afraid of being dragged out of my vehicle and beaten by these two officers on a road where there were no vehicles at that time or minimal traffic, because it was 1 a.m. and it was a dark street with no lights, adequate lighting. So I was in fear for my life, complied. I didn't reach for anything. I didn't reach for ID, a phone. Only brought out a container of juice and kept my hands on the juice container at all times because of medical reasons. I need to drink liquids. So I kept that container of juice and kept both hands on the container of juice in visible sight and placed it on the vehicle. Then I submitted to arrest, and then I asked to be detained and placed in the back of the vehicle while they continued to search, so that would not be confused as restraining or refusing arrest or fighting against the officers, resisting arrest. So I immediately asked to be detained, where I'll be in view of the camera at all times, from the point of exiting the vehicle up to the point I was lodged in the back seat. The back seat cameras were rolling as well, to guarantee my own safety.